Hi, everyone. This is Sam Silverman, Managing Partner of EB5AN. Thank you for taking time to join us on today's webinar. Today, we're going to be discussing adjusting status with an EB5 investment, and we'll also cover some recent EB5 visa demand trends and see how investors have been joining both rural and urban TEA projects and what those implications are for new investors considering either of those project types. All right, here's a quick overview of what we'll cover. We'll spend a few minutes talking about EB5AN, then we'll introduce our guest panelists. We'll talk about adjusting status. We'll talk about some recent visa demand trends for rural and urban TEA projects. And then we'll spend a couple minutes on some of the available urban and rural TEA projects available today. A little bit about EB5AN. We're a leading EB5 investment fund manager. We've worked with over 2,000 families from more than 70 countries. We have regional centers that cover most of the United States, which allows us to select projects across a wide geographic area. One of the things that makes us unique in this space is a commitment to investment transparency. We're one of the few, if not the only firm that makes all of the documents, including financial statements, available to investors prior to making an investment, so they have access to the full set of available information about the project before making a decision. On our website, we have a very active blog with hundreds of articles and a YouTube channel with over 1,000 videos with a lot of informational content about real estate development, how to analyze potential projects, and differences between debt and equity options as well. So please take a look at that when you have time. As I mentioned earlier, I'm Sam Silverman, one of the two managing partners of EB5AN. A little more about my background and bio is there on the left-hand side of the screen. This is a map showing our regional center coverage. This allows us to pick the most compelling EB5 investment projects regardless of geographic location. And another map showing where many of our historical investors have come from over the years. We've been fortunate to have many of our articles and projects featured in many of the leading publications. Some of them are listed here. And now it's my pleasure to introduce our guest panelist, Belma Chinchoy, who's a very experienced EB5 immigration attorney who's been in this space for quite a while. And I'll let Belma jump in and introduce herself and share some details about her experience working with EB5 investors under the current EB5 rules in both rural and urban TEA projects, and also previously before that under some of the prior rules.
All right, thanks, Sam. Thanks for having me on the webinar. Yeah, as you said, I'm Belma Chinchoy. I'm an immigration attorney based in Los Angeles. My practice focuses on EB5. I have been doing this for almost 15 years now, primarily representing investors, but also in some cases, I do help set up projects. And so I have a really solid understanding of what it takes to pick a successful EB5 project, and that becomes essential for our clients, investor clients that we represent through the process.
All right, perfect. All right, so today's discussion first is going to focus on adjusting status. So, Belma, can you tell us a little bit about, what is adjusting status, how does it work, and how does it fit in with an investor who's considering making an EB5 investment, and what that kind of benefit is for the investor and his or her family?
Yeah, absolutely. I mean, in brief, one way to look at it is honestly that adjustment of status is truly where the benefit of doing EB5 and at this time for a lot of investors that are located in the United States, because this is where the benefits of immigration come from. So what it actually means, adjusting the status is literally addressing the adjustment to residence from a non-immigrant status that the investor currently holds in the United States. That non-immigrant status is typically a non-immigrant temporary visa status, and adjustment simply refers to the process where we change that investor from the temporary non-immigrant status to residence. The process itself is that it's done through the USCIS, and as many of our viewers probably know, that this is something that's only become an option for EB5 investors as of 2.5 years ago, since 2022. EB5 investors used to not be able to file what we say concurrently, meaning that at the same time that an investor files the Form I-526 or 526E specifically petition, they weren't able to file for adjustment of status at the same time. But now that is available, and that's truly the real benefit of being an EB5 investor who is in United States in non-immigrant status and valid non-immigrant status. They can file the residence application form 485, if anyone is keeping notes on what all these forms are called. And this process adjustment allows investors to really realize the benefits of residence almost immediately, essentially. The residence itself doesn't come for, depending on the processing times, probably 18-ish months or so, or sometimes even a little bit longer than that. But the benefits of employment authorization and advanced parole or the travel documents are realized much sooner than that. So even though, as I said, the actual residence is not issued for some time after the filing, the adjustment process does have interim benefits that allow investors to realize the perks of being a U.S. resident, and those perks obviously are sort of ability to work for whomever they want and wherever they want, including for themselves, running a business, owning a business, working for an employer and owning a business. You could do all of those things when you have a free and clear employment authorization that is not tied to a visa status. Did I answer all the questions, Sam? I know it was a multi-part prompt.
Yep. I think okay. Let's spend a few minutes now and just talk about what the different initial visa statuses that are available, to do an adjustment of status from, and how that adjusting process works if you're on one of these existing statuses.
Okay, perfect. Yeah, this is a great slide that really breaks it down very nicely. So these are the sort of the temporary, non-resident, non-immigrant, visas that individuals can hold while they are in the United States. These are the most common ones that we see with potential EB5 investors. And the B1 is the tourist or visitor visa for business or for pleasure. B1, B2 visa, it's most common type of visa that most individuals that come to the U.S. for a temporary visit, again, as a tourist or as a business visitor, that's the status they hold. The asterisks you see here, so it is a status and that allows a person to file for adjustment of status from that particular B1, B2 status. And the reason you have this asterisk here, it's important to note that this is strictly a non-immigrant visa, meaning that a person holding this visa was given this visa, was issued this visa by the U.S. Department of State because they demonstrated their non-immigrant intent. What that means is that they demonstrated a lack of immigrant intent, lack of desire to use this visa to come and stay in the United States permanently. The reason why somebody is able to actually file for adjustment is it's sort of the natural questions like, well, if this is a non-immigrant, single intent, non-immigrant intent visa, how are we able to file for adjustment of status? And it's doable. We have done it. I'm sure you have many investor clients who have done this process as well. So what it really comes down to is that when a person enters the U.S. on a B1, B2 visa, they need to have a non-immigrant intent at the time of entry, meaning that there are certain things we look for when we speak with our clients to make sure that we can establish that they've had a non-immigrant intent at the time of entry. And why this is important is because a person can change their mind. We all do regularly, and that's all right. And immigration recognizes that. But there are certain things that we do have to watch out for. Some of the most common ones being, when do you file for adjustment of status if you're exiting B1, B2 status? You cannot do it the day after you arrive, because obviously, yes, we can change our mind in 24 hours, but that's not very likely. And it's also kind of impossible to do that when you are transitioning from a B1 to EB5. And the reason for that is that EB5 takes some research and planning, and it's a process, right? So you couldn't have really prepped for EB5 if, within 24 hours, let me put it that way. So timing is really important. 90 days is a presumption timeline, so you really want to wait 90 days. There are several other categories that I, as an immigration attorney, discuss with my clients, and I review their documents. I make sure that we really do a plan for that. We don't want a client to end up getting a notice of intent to deny because immigration has concluded that they had immigrant intent and had violated the terms of their visa, etc. So it's not something we address in an adjustment filing, but we do a lot of background work before we tell someone, you can go ahead. We feel fairly confident that this is okay. So similar to F1 visa, F1 is a student visa. Again, a lot of our clients are students in the US, and they are planning for their future and understanding that H-1Bs can be difficult to get. And so if they are in a position to secure an EB-5 visa for themselves, it's generally a really good option. So F1 is also non-immigrant, but also notes that F1 students, they live in the United States for an extended period of time, sometimes for, 1, 2, or 3 degrees. So it's absolutely natural for them to have the desire to change their status to residence. They tend not to be questioned even. The non-immigrant intent becomes lesser of an issue. We've even had clients who have filed 526E petitions and subsequently sought F1 visa and were issued that visa because it's a process, right? So similar to what I said with the B1, B2, there are a few things that we do our due diligence on to make sure the clients, sort of check all the boxes in preserving their compliance with all the rules, EB5, of course, but also the previous visa F1s. But to be clear, a lot of our clients are transitioning both out of B1, B2, and also F1 towards an EB5 visa, and it's doable. The next two categories, H1B and L1, and all the derivatives of that, are, as most everybody watching this webinar knows, these are work authorized visas or employment visas for temporary work status. What's great about these two visas and why they don't have an asterisk next to them on our slide is because they are dual intent visa by statute. So the actual law that put these visas into regulations said that it is perfectly okay to have immigrant intent while also applying for H-1B or L-1A or L-1B visa. So a person can be absolutely open about their desire to adjust for residence and pursue residence at a later date. What's really great about H-1Bs and L-1s, sort of like an added perk of that dual status, is that you can continue to maintain your H-1B visa and your L-1 visa even after you apply for adjustment. This is not the case for the non-immigrant categories of B1 and F1, but H-1Bs and L-1s, because they are explicitly dual intent, then applicants can continue to maintain that status and continue to use the actual visa as long as it's valid to travel. So you could be in H-1B status, file for adjustment, and then a week later you could travel out of the US and return and seek admission in H-1B status, assuming that you are still going to maintain that H-1B status, of course, right? So that's the added benefit of H-1B and L-1, because they are dual intent. The person can continue to maintain that status, and you can continue to use the valid H-1 or L-1 visas to travel. The E-2 visa, the last category on this slide, this is also a temporary non-immigrant visa, commonly known as the entrepreneur visa, also investment-based in many cases, but it is temporary. And what happens with this E-2 visa is, in terms of the intent, it is not a dual intent expressly. So nowhere in the law or the regulations does it say that E-2 visa is a dual intent visa. But from a practical standpoint, there is a little bit less concern with perhaps maintaining the 90-day before filing, just because it's treated slightly differently. But it is not a visa that you could use to travel on after you file for adjustment. So it's definitely something that we caution our clients, like, once you file for adjustment, you do need to wait to receive the interim benefit of advanced parole before traveling. The other category that I'll just throw in there that's related to this is the E3 visa, which is basically essentially the H-1B visa for Australian nationals. That's similar, well, identical categories in terms of eligibility, but it is specific to Australian nationals. But it falls into the same category of the visas that are listed here as one of the visas individuals can adjust from to residence.
Okay, perfect. All right. Now we talked about kind of the different eligibility criteria. Let's spend a few minutes now and just kind of walk through what that whole process looks like for an investor considering EB-5, and then how the different government filings kind of fit together in terms of timing.
Yeah, perfect. Yeah, this is the EB-5 process in a nutshell. And as you mentioned, the entire process for EB-5 generally begins with identifying the project that the investor is interested in and completing that process of subscription and the investment, right? Because the EB-5 petition is investment-based petition, what that means is that, generally speaking, the investment must be made prior to any filings to immigration. Now, this is a very common question that I receive. It's like, well, when can I invest? Can I file now and then invest in 6 months? And there's some flexibility in terms of completing your full investment at the before filing, but generally speaking, there has to be an investment in order to allow an investor to file the EB-5 petition form I-526E. So once that first step is completed, the actual subscription and investment, then the investors proceed to what we call now the concurrent filing, the process of adjustment of status. And so that involves the filing of 4 separate forms or petitions and applications. So the EB-5 petition, the form I-526E, which is, again, the petition to be classified as an EB-5 investor. And that is the petition that demonstrates that investment has been made, that an investor's source of funds have been reported in detail, the path of the funds has been completed. So the eligibility for EB-5 has to be established in this 526E filing. Then the adjustment or the residence part are the next 3 forms. So form I-485, that is the actual application for adjustment of status or registration of residence. The investor files that for themselves. And so each person in the investor's family would be filing the next 3 forms on their own. The adjustment is per person. The form 526E, the EB-5 petition, covers the entire family, assuming the children are under 21. So form 485 is the residence application that essentially demonstrates the applicant's intent to adjust status to residence. And then the next 2 forms are the interim benefits that I just mentioned previously. And these are really important for most individuals that are considering this process because, again, this is where you get the benefits of residence while you are waiting for the actual residence to be issued or approved. And so it's the real benefit of concurrent filing is being able to file these interim benefit applications. So the Form 765 is the employment authorization, and the I-131 is the travel authorization. Specifically in this case, it's called the advanced parole. So these are the documents that are issued, or I should say adjudicated prior to both the 526E in most cases, and certainly before the 485 residence application. What we've seen, and Sam, I'd love for you to chime in on this too. Like what we've seen is that the employment authorization has been fairly quick. I'd say 2 to 3 months has been the standard over 2024, let's say. Which is great because that means that you could, as soon as you receive that employment authorization, you are eligible to work. You can also apply for a social security number in case you don't have one. And then there are implications of having a social security number that are beneficial to life in the US. And so that's done pretty quickly. 2 to 3 months is great. The most recent employment authorizations have been issued for a period of 5 years, which, we're hopeful that our clients will have their residence well before the expiration of that 5-year EAD. But it's nice to have it because you don't have to worry about renewing it. You don't have to ever worry about having a gap in employment authorization, so on and so forth. So that's been our experience, 2 to 3 months on the 765s. The I-131s, the advanced parole, that's the document that authorizes your return to the United States after international travel, which basically demonstrates that you have a pending residence and you should be admitted on this advanced parole. That document has been a little bit slower in our experience in terms of adjudication. So it's been about, I'd say 8 to 12 months in most cases. Sometimes we're able to get emergency advanced parole for travels that qualify for emergencies, but generally speaking, it's been a bit longer. And again, this really ties to the previous slide of H-1Bs and L-1s. The benefit of having a valid H or L visa is that you can continue to use it to travel as long as you're maintaining the H or L status before this advanced parole comes back. But that's sort of the top part of the slide is really sort of addressing everything, before anything has been approved in terms of residence or the 526 petition. You should have the 765 and the I-131 approved within, anywhere between 2 and 12 months of filing, and that gives you the ability to really enjoy the benefits of residence in the U.S. And then moving on to the lower level, the 526 approval should come next. The timing, has been, I know you have a lot of data on this, so maybe we'll talk about the timing later on. But ideally, you should see that within a year of filing. And as soon as the 526E is approved, that clears the way for the residence to be approved as well. The 526E is the basis of the residence application. So the residence application cannot be approved until the 526 has been approved. Once the 485, the residence application has been approved, that is the conditional residence start. So the investors or the EB5 clients, they receive a temporary or conditional green card, which is valid for a period of 2 years. Once that green card is issued, just to be 100% clear, the employment authorization is no longer relevant. The I-131 advanced parole is no longer relevant because now you actually have residence. It's conditional, but conditional really doesn't necessarily have any impact on how you live your day-to-day life in the United States. So you have the residence, which you can use for employment and for travel and, to demonstrate your status in the United States when you're applying for school, when you're applying for financing, various other things, right? So before the end of the 2-year conditional residence, there is a process that investors have to go through to remove the conditions on their residence. So investors file Form I-829 with USCIS to petition immigration to remove the conditions on their residence. At this time, investors are basically demonstrating that all of the EB5 requirements have been met, that their investment, obviously was made properly, that it was sustained for the required amount of time, that the projects did what it was supposed to do, or what it said it was going to do, and that it created sufficient jobs for this investor to demonstrate no less than 10 jobs created as a result of their investment. And then the petition, 829 petition, can be approved, and residence conditions can be lifted. Once the petition, 829 petition has been approved, investors receive a permanent residence, permanent green card, valid for 10 years, but that validity is simply sort of like a matter of form. It doesn't mean that their residence is valid for 10 years. The residence is permanent, but the card itself will say 10-year validity period. And also one thing I want to note is that those clients that are considering U.S. citizenship, they should know that the conditional residence, or time spent in conditional residence, counts toward the requirement of 5-year residence in order to be eligible for citizenship. So as soon as the investors receive the conditional green card, that 5-year clock starts ticking for citizenship. And of course, there are other requirements that have to be met, but in terms of the 5-year residence, conditional residence qualifies for that period.
Thanks, Belma. And I think just to kind of add some color on our perspective in terms of some of these timelines, for EAD and advanced parole, we're seeing the fastest one we've seen is about 30 days. Okay. Most of them we're seeing in about 90 to 120 days, so 3 to 4 months. Mm-hmm. And then in terms of 5 to 6 year approvals, we've seen almost 200 approvals in our rural projects, with the majority of those, recently trending in kind of the 7 to 9 month window for approval. Okay. So definitely a lot faster for rural than for urban, and well within the 12 months that you mentioned. So yeah, that's definitely what we're seeing as well. All right, I think we can. Let's just spend 1 minute, Belma, and kind of summarize what this process looks like. A lot of these things are kind of overlapping, but yeah, walk us through kind of how these fit together.
Yeah, this is a great chart, because it really does tell you sort of what processes are happening concurrently, and in this case, all other processes are happening concurrently. So, but from the date of filing, the 526E and the 485, they have the longest timeline in terms of adjudication, and an endpoint is that temporary green card. As you can see on this chart, it's showing it roughly 18 months. So that's absolutely a reasonable time frame. But then the next categories, in terms of the 765 and I-131, the interim benefits, they have shorter timelines for processing, and employment should be the first one that comes, and that's the one that matters to most people anyway. So that's really important for prospective investors to realize that this is truly, again, the benefit of concurrent filing, is that you can realize these benefits. And then the 829 petition, that's down the line once the temporary or conditional residence process has been completed. And this is just the timeline for that the law sets out for us. So it's not like investors could do something to speed up the processing. Like 2 years is 2 years, but investors can do something to speed up the processing of the 526E and 485, and that's generally, having great package presented to immigration, making sure they're picking the right project that isn't going to have RFPs, or a project that already has an approval, and all of those things that you could sort of make sure you prep on the front end to decrease the overall timeline. But roughly speaking, 5 years is the projected timeline to be in the EB5 process altogether, with benefits coming much sooner than that.
Gotcha. Okay, that's a really good summary. And let's get a little more specific. We talked about EAD and advanced parole, but what are the real benefits for each of those, and how is that really helpful for someone who's in the U.S. on, let's say, F1 or H1B? What does that give them that they don't have, and how does it differ from what they'll eventually have when they get the green card?
Yeah. So the employment authorization is how, that allows a person to work in United States. And this particular residence-based employment authorization is employment authorization that comes with no strings attached, meaning that the holder of that authorization can work anywhere they want. There is no sponsorship required in order to receive the job or be able to work for an employer, meaning there's no employer sponsorship required. What I'm hearing from a lot of our clients is that not having job mobility or having the job mobility restricted by the visa status, such as H-1B, is something that is problematic, right? And this job mobility can mean a lot of different things. It can mean geographic mobility. Sometimes people want to live in a different part of the country and want to work, closer to family or something along those lines, right? Or in a different climate, for all that matters. But most often what that means is simply being able to have greater negotiating power when it comes to the jobs you take, the position you have, the employer you work for, the salary you receive, so on and so forth. Sponsorship by an employer oftentimes removes a little bit of agency from the employee to be, because they are dependent on that sponsorship, right? So you don't necessarily have as much leverage in negotiating your package, your position, the location, etc., right? So employment authorization that's based on residence has no strings attached in terms of, again, like employer or location. So investors can work anywhere they want to. They can apply for any job, and so the job application typically says, do you require immigration sponsorship in order to take this position? You can simply say no, right? And that opens up a lot more jobs, basically. It also matters that you can run your own business, right? Like, you no longer need to be sponsored by an employer that is not related to you. So you could run your own business. You can also run your own business and work for an employer. Like, truly, like, essentially, it opens up the employment 100%. So they could really work wherever they want and however they want. The employment authorization also allows individuals to apply for Social Security number, like I mentioned earlier. And what this really means is sort of puts you in a different category of an individual in this country, right? People that have a Social Security number with no limitations or no annotations written on that Social Security card, are treated a little bit differently when it comes to, again, opportunities related to school applications if they want to. And sometimes this is more relevant for the investor's children, like applying for college as someone who has resident status or close to resident status. Applying for financing, say you want to take on a mortgage to purchase a home, either your primary home or your second home, vacation home, etc. It opens up different banking opportunities, different financing opportunities, I should say, credit opportunities, right? And most people that live in the US know that in order to really function in this society, you have to establish credit worthiness. And the way you do that is by taking out credit and demonstrating that you are a responsible person who's going to pay their financial obligations on time. And so having a Social Security number gives you a different profile. You're a different profile of a person, essentially. So employment authorization gives that option. It gives an unrestricted Social Security number. So how is that different from H-1B or L-1? Again, it's really that availability or the possibility of working wherever they want, owning your own business, doing both at the same time, working anywhere in the country, and really being able to apply for a lot of jobs that do not offer the opportunity of working under sponsorship, right? In some cases, it can also open up certain segments of industries, like defense industry, et cetera. So there are nuances to that, right? Some jobs are simply not open to anybody but US citizens, so it's not the same as that. But it really does make the job market so much more accessible than what H-1B would offer or even L-1 would offer, right? Because H-1B and L-1 are employer specific, and you can only work for those employers that sponsored you, and you're not allowed to have other jobs, income generating jobs at the same time. For F1 students, what this means is it means the ability to work, right? You don't have, as an F1 student, the opportunities to work are very limited, and they're governed by the school and the F1 regulations, of course. But generally speaking, very limited opportunities. You cannot access the general labor market, and having an EAD after F1 status, you really can. You can work while you go to school if that's what you choose to do, but it also obviously opens up the labor market after graduation. So really a significant bump forward. The advanced parole, travel authorization, it really gives you the ability to travel in and out of the country. You don't have to maintain a visa that is valid. If you had an H-1B visa and you decided that you no longer want to maintain that status, but also the visa is expired, as some countries have very short periods for visa validity. And even though the H status is valid for 3 years, generally speaking, in 3-year increments, I guess, but some visas are only valid for a year. So these individuals would have to extend that visa annually. But once you have the advanced parole approved, you don't have to worry about having that visa valid in your passport. You can travel freely. It also protects this is an essential part of the advanced parole, is that it protects your adjustment of status, or your intent to proceed with the adjustment of status instead of abandoning it if you leave the US, right? So it's very important that if you don't have H or L status, you cannot travel until advanced parole has been approved. So this document is an indicator that you have immigrant, you don't intend to abandon your residence. Most people report that travel on advanced parole is perfectly fine. I know it does require a little bit more scrutiny at the border, because this is a temporary, kind of an interim document for travel. But honestly, most of my clients say it's fine. I always prep them for it. I always tell my clients, I want to know when you're leaving the country, and I want to talk about it, but just to be 100% clear, and that what they need to bring with them, etc. But most of the time, clients say, like, it's no big deal. They do have to go into secondary inspection at the border. It's pretty quick. Immigration is simply verifying that your 485 is indeed pending, because that's what this advanced parole is based on. But more or less, it's a pretty easy process for traveling. And again, you don't have to maintain that visa. If you have advanced parole, you are allowed to come back you're allowed to be paroled into the country after temporary travel abroad.
Got it. Perfect. Thank you, Belma.
Yeah.
Let's talk about that adjustment of status now in the context of locking in a child's age, and how, what are the rules for that, and why does it matter, for clients who may or may not, face a visa backlog in the future?
Yeah, absolutely. This is a very important consideration for many clients that are in the US, and that they want to make sure that their children are eligible for the residence based on that one EB5 investment. Like I mentioned earlier, the 526E petition covers the entire family, and that is an immediate family, meaning a spouse and children under the age of 21. So a person can file a form 526E, and then before the residence is realized, or before they're able to apply for residence, sometimes the children will age out. That's sort of what the general process of turning 21 is called in immigration. So what happens, right? So there is a law called CSPA, Child Status Protection Act, that basically is meant to protect the rights of children that are in the process of seeking residence, be it under a petition or to an actual adjustment of status process, and give them a right to sort of retain their underage, under 21 status, right? So the way it works is that immigration processing time, the time that USCIS takes to process a petition does not count against a person, in this case, against a child, right? So the age is technically frozen, is what we say. So if a family files a 526E petition when their child is 20, then that child stays 20 years of age while immigration is processing that petition, right? So the age is frozen during the pendency of immigration's processing. When the petition is approved, then that age continues to advance. So there's basically like a little chart, a little formula that we would typically include in an application when this is relevant, to demonstrate the child protection status or Child Status Protection Act applicability to a case. What happens, with adjustment of status is a little bit different, right? Because Child Status Protection Act was really important and continues to be very important for many for many categories, immigration categories. It's become a little bit less important for EB5 because of the concurrent filing, and there is the law can be a little complex, and I'm trying to figure out how to make sure I'm demonstrating this or articulating this very simply. There's sort of two elements in the CSPA calculation. One is that the age is frozen during the pendency of the petition, but then once a person is eligible to pursue residence, they do have to do that within a certain period. So there is essentially there's a requirement to seek that residence immediately, essentially, right? And so what the concurrent filing for adjustment of status has done, and I think it's essentially eliminated that, because filing of the 485, the residence application, essentially meets that requirement of sought to require. Now, I think you're right to point this out on the slides, that there is no official written guidance or precedent decisions confirming that this is the correct interpretation. But also it's pretty hard to see how it wouldn't be, because this person has in fact filed their 485 at the time when they were eligible to do so, correct? And once you have made that filing, then you have established your eligibility at the time of filing. Immigration law can also be very complicated, and there are rules that look at the time of filing versus time of adjudication and so on and so forth. But we're feeling pretty confident that the submission of the form 485, when a person is eligible to submit that form, does protect your status as underage, as a child under the age of 21, who has fulfilled the requirements for adjustment of status.
Okay, perfect. All right, we talked about this. I think we can skip over that. Let's talk about some just recent mistakes that we're seeing with USCIS, and how, as the client's immigration counsel, even if you submit a perfect application, how do you kind of deal with some of these mistakes and try to avoid them going in? But then if they still happen, how do you quickly correct them so they don't result in extensive delays that put the client in a bad spot?
Yeah, absolutely. Yeah, I mean, I think this is where it's really essential to make sure that investors work with diligent immigration counsel, and also at the same time, to understand that, look, we're all human, right? Mistakes can happen, but then the question is, what do we do about it? Like, are we going to put in the effort to correct the situation and make sure that everything works out without delays? And these mistakes can happen both on the filing side and also on the receiving side. USCIS, we all make mistakes every once in a while, but how do we solve these mistakes is what really matters. Working with an immigration counsel, the idea is that we really try to anticipate all potential pitfalls, if you will, right? And the goal is to have a plan in place for every possible scenario of something not going right. In 2022, when concurrent filing first became an option for EB5 investors, we used to see a lot of rejections, and this was sort of a training issue on the USCIS side. As you know, Sam, and I think some of our viewers here probably do know that immigration is a very large agency, and we're not necessarily, it's a multi-tiered agency too in terms of levels of knowledge and levels of skill. So before a filing or before an investor's application gets to an officer who is a very well-trained, experienced adjudication officer, it goes through several levels of most likely contract staff, right? And so training issues in the initial periods of any new interpretation of the law or any change in the law, training issues are very common. And so we have seen rejections basically for it stating that you're actually not eligible to file concurrently. You have to wait for the 526 to be approved. We've seen application rejections for saying like, you cannot file for all of your family members. So there's a myriad of kind of issues that can happen at that initial first point of contact. And you have a screenshot here of a lockbox support. And that's basically, lockbox is the contract unit that receives the mail on behalf of USCIS. I will say that over the last couple of years, I've seen a concerted effort by USCIS to really fix their own mistakes through venues such as lockbox support, direct access to adjudicators, local adjudicators. As I mentioned earlier, I'm in Los Angeles. One of the large USCIS district offices is here in Los Angeles. We have, I would say, a pretty good relationship with USCIS staff, and by we, I mean immigration attorneys that are involved in some of the advocacy work and involved in some of the policy work. So we have direct access to some of these individuals. And obviously the EB-5 petitions are not being filed at the local district office, but sometimes having a relationship with the USCIS staff gives us access when there are problems, right? EB-5 petitions, I think, work pretty well, but it's the adjustment that sometimes there's issues with it. So, having an attorney that, works collaboratively with the client and is, willing to take the steps immediately to correct any issues from USCIS, knows a few venues through which remedy can be pursued, be it through the lockbox support, Ombudsman's office, local USCIS, the IPO, of course. So there's definitely ways to address issues when cases are kicked back erroneously, but it happens. It really does, and I think that's just the reality. And I don't think it reflects poorly on anyone's, quality of work or their diligence. But sometimes this does happen, and I mean, I've had cases of USCIS writing and saying, we lost your application. Could you please resend it? We don't have any of it. Or, we are missing the last 15 exhibits that are listed on your exhibit sheet. We don't have them. The process of scanning petitions, I think, is helping with this, because officers are less and less walking around with bankers' boxes full of papers, but that's still happening. So staying on top of cases, monitoring processing time. If we see a rural petition that has been pending for more than 12 months, it's time to get involved. And actually, I'm in the midst of doing that with one of my clients. It's been more than 12 months. The project that they invested in has had approvals. So I know it's not the project issue, but for some reason, my client's petition hasn't been looked at yet. So we're putting sort of gears into place to, okay, what's going on? Why did this case get misplaced? Really is what it comes down to. But really trying to do that before too much time goes by, because that also impacts the client's timeline.
Yep, got it. Okay, all right. I think let's shift gears now and spend a few minutes on some recent EB5 visa trends. So over the last 10, 11 years, we've seen the program hit kind of its highest points back in 2016, 2017. And then, with COVID and then the program lapsing, the regional center program lapsing, we saw, volume really drop in 2019, 2020, 21. And then under the RIA, under the current set of rules, we've seen volume, really accelerate over the last 2 years. And that's kind of what we expect to see in the future. And to dig a little bit more into some of those rural I-526E approval statistics that we mentioned earlier, we've seen almost 200 approvals so far in rural TEA projects that EB5 has administered. All of these have gotten their 956F approval already. And what's really interesting here is that as time has gone on, in the last 12 months for all the filings, that we've seen, really towards the end of 23 and through 24, so far that we have data on, we're seeing the timelines become a lot more consistent. And so you can see this trend line here that a lot of the dots are a lot closer, kind of located along the trend line. And you can see that the green box here represents filings being approved within 10 months. And so as time has gone on, there's a much greater chance that your application is going to get approved, more consistently in kind of that 7 to 10 month window. And that really makes sense logically because the government, it takes time for adjudicators to get up to speed on the new rules, for projects to get approved and, to really staff up and, become more efficient. And now we're seeing that, really start to happen, 2 years after these rules went into effect.
Yeah. I think just one quick, I don't really have anything to add. I think this is perfect, but I just love that you guys are keeping track of this because this is really helpful to see. As we know, the data is often very dense and hard to come by. So it's really good to see this represented visually. And obviously the trend is going in the right direction, under 10 months is obviously amazing.
Yes, exactly. And as Belma, just mentioned, this data is proprietary to EB5's own rural projects. Some other regional centers, may or may not choose to publish this data, but we really believe in transparency and just making sure investors have, as much information as possible. Obviously, this is historical, right? So, it's not going to exactly, guarantee what's going to happen to investors filing now, but it is, it is good to see the trend as to where things are going. One of the other pieces of information that we really like to highlight on is just rural versus urban. And obviously rural, is going to get much faster processing, more in the 7 to 9 month range, whereas urban is going to be a few years. And so, you can see kind of how the breakdown in terms of applications through, through midway last year has looked. And what we're seeing, and this isn't in this chart, but we are seeing a trend toward more rural applications, more toward that 50-50 breakdown. And that's really what we expect to see going forward. And then when we look at that same data of how many applications have been filed in both rural and urban, and this is our opinion, obviously, we believe that it's pretty clear that the urban unemployment category is going to see a backlog, fairly soon. And likely a few year backlog when it does show up eventually on the visa bulletin. Whereas for rural, we think the current pace of applications is close to being in line with what available visas look like for rural. And obviously, there's a lot of different factors that go into this analysis, ability to get an interview, actually get the green card. So it's a very complicated analysis, but if we try to simplify and just look at how many visas have been filed, how many applications, how many visas are going to be needed per application, and then how many visas are available. We get to the basic math that we see here.
This is also, I think, very instructive. I know a lot of potential investors are very data driven, and I think, as you said, it's a complex calculation, but on some level, right, like we have to assign values somewhere. So this is a really good place to start in understanding what's likely to come. And yeah, it's very, very helpful to see these numbers black on white.
And one of the things kind of in terms of a new development that's happened recently is some new warning language has been present in the most recent January visa bulletin, which came out about a month ago. So Belma, can you walk us through this, and what is the Visa Bulletin? Why does it matter? How do investors interpret this warning? And kind of tying this back to our adjustment of status discussion, how does that fit in with potential clients in the U.S. who are considering, going for an adjustment of status?
Yeah, absolutely. I mean, this honestly did not come as a huge surprise to anyone who's monitoring the industry and paying attention to what's been going on. And as the previous slide showed, there have been quite a few 5 to 6 petitions filed, and each one of those petitions implies that a few visas are allocated to those petitions. So going back to sort of what is the Visa Bulletin? So the Visa Bulletin is essentially a schedule that the Department of State publishes monthly that tells us what visas are available per immigration category. The reason we have a Visa Bulletin, why we need to have this schedule, is because there are caps on how many visas we can issue per category, right? Everyone is familiar with like H-1B, 85,000 a year. But correspondingly, the residence visas also have an annual cap. So only a certain number of visas can be issued every year. And that's set by law. That's just how it's been for a long time. Immigration is broken down into categories. So different categories of residents have different allocation of visas. Family is treated separately from employment-based visa categories. Most individuals tuning into this webinar know that EB5 has 10,000 visas allocated under the overall employment residence category. So what the Visa Bulletin says is, here is this pot of visas, and here it's broken down per category, and it tells you what categories have greater demand than visa availability. So when that happens, when there's more applicants for a visa than there are visas available in that particular fiscal year, then there is a backlog, right? And immigration posts this backlog, or the Department of State rather, posts this backlog on the Visa Bulletin by telling us what application date is current, or what priority date has a visa available to it, and that is indicated by noting that that particular category is current. And on the actual Visa Bulletin, that is indicated with a letter C, so C for current. And so it's a little bit backward in the sense of how it works, and looking at it for the first time, it's a little confusing, but if you speak with someone who is well familiar with this, they can walk you through it and understand kind of like what I just explained. So a person, when you see a C in a category, that means a visa for that particular residence category and that particular country of origin. And here we are talking about country of birth, regardless of what the nationality is, with only a few exceptions, small exceptions to that. So generally speaking, what country you were born in determines your country of chargeability as far as visa allocation is concerned. So if there is a C on the Visa Bulletin, that means visa is readily available to you. And for the purposes of this webinar, it means that you can apply for adjustment of status right then and there. The requirement is that the visa be currently available to you before you can file for adjustment of status application. If you see a date listed, say it says, January 1, 2022, so that is a priority date, which indicates that visas are only available to individuals that have filed their petition prior to that date. So if your petition has a filing date that precedes the date listed on the Visa Bulletin, then a visa is available to you and you are able to pursue residence by filing adjustment of status application. So for the time being, EB5 categories post RIA are all current, but as you said, Sam, in January, the warning or the heads up finally came with the Visa Bulletin. It says, we are looking into establishing the date for filing and final action date during this fiscal year. So what that means is that backlog is coming this fiscal year, which we're now in the Q2 of this fiscal year, which started on October 1, 2024. So no one knows when, right? Immigration probably doesn't know when either, but it's coming and it's anyone's guess, right? So what we do know is that we have the visa bulletin issued, roughly speaking, 20 days or anywhere between 20 and 14 days prior to the end of each month. So that tells us, the March visa bulletin is going to be issued in mid-February. The February visa bulletin was just issued last week. So, we have a little bit of wiggle room there. So when February visa bulletin was published, we still had about 2 weeks to file under the January visa bulletin. So worst case scenario, a potential investor could be contemplating EB5, and then a visa bulletin is published for the next month, and it says a visa is no longer available to you, now you have a backlog. That means they have 2.5 weeks to get that petition and adjustment of status residence filed. This may or may not be possible depending on the investor's source of funds and their ability to put the documentation together, and just how far they are in the EB5 process. But sort of it's not all lost. If, should that happen to somebody, you could still potentially make it, but it's going to be rough. So again, I think all of us that work in this space, the best advice we can give to potential investors is, we know it's coming, so if EB5 is really the right option for you, then now is the time to do it, because why wait and then potentially deal with lack of availability of good projects, because good projects do sell out every once in a while and very quickly. Also, you might be facing potentially expedite fees. If you approach an attorney and you say, I need you to drop everything for the next 10 days so that you can get my petition filed, that's going to come with an extra fee, expedite fee, so on and so forth. So don't put yourself in that position. Do your due diligence now and know it's coming. That's really all we can say.
All right. Thank you, Belma. And, no one knows the future, but again, history does tend to repeat itself. So let's spend a minute and just talk about kind of what we've seen in the past. This isn't the first time we've seen a warning like this show up on the visa bulletin. So, you've been in this space, for 10 plus years. How has this played out, historically?
Yeah, I mean, this chart I think is very indicative of what we've seen, and in particular, what we've seen with these 3 countries that have had backlogs in visa under the EB5 category. China has been affected most drastically, I think, and the backlog first started in 2015. It happened in 2015. It's the current priority date is now in 2017. It's been an exceptionally long time period. The really important thing for listeners to understand is that the visa bulletin does not necessarily move day for day for a calendar day. So, if it says January 10 on the visa bulletin and now it's January 21, you shouldn't assume that the backlog has advanced by 11 days. Like, it doesn't work like that. It's actually not even close to that. Like, if you look at some of the historical visa bulletins, which are all available on the Department of State's website, you'll see that it moves actually very slowly, generally speaking. Sometimes it makes great advances, other times it doesn't. Most of the time, it really moves very slowly. So, as in this particular case that we're looking at, the warning came 1 to 3 months before the cutoff date. I think that's pretty standard. It's truly a heads up. Like, it's not really a question of if, it's the question of when. So investors that know that this is going to happen. And that they need to apply for adjustment at the time of EB5 petition filing. It's the writing is really right in front of them. They've got to act now. Most likely, the visa bulletin is going to impact the 3 countries that are listed here. Certainly China and India, Vietnam potentially.
Yep, perfect. All right, and so, for an investor considering EB5, how does the adjustment of status kind of interplay with the visa bulletin and being current and not? And let's kind of walk through, one or two real life examples here.
Okay. This is a great chart. Let me kind of take a step back to make sure what I'm saying is matching. So the visa okay, so I see you're saying here the visa bulletin is published roughly 26 days before the end of each month. Sometimes it's closer to 2 weeks, but yeah, that's been a trend recently. So we know that, current categories under the January 25 visa bulletin, everything is current for the EB5 rural and high unemployment areas. There is no impact to any country. The same for February 25. We know for a fact that up until February 28th, I think this year only has 28 days in February, we can file adjustment of status application under both the EB5 rural and high unemployment category, regardless of the investor's country of origin. For March, we don't know, right? We haven't seen it. We might see a cutoff date for Indian investors, for Chinese investors. We're going to find that out in the early February, hopefully early February, not mid-February.
Okay, perfect. All right, so we don't know when that will happen, but as soon as it does get announced, there's going to be a few weeks where investors will still be able to file an application and adjust status before the window closes. So that is really helpful to know. Although when that does happen, it's likely that Belma and pretty much every experienced EB5 attorney is going to be inundated with new clients, wanting to meet that same deadline, and it's unlikely there's going to be much capacity with experienced attorneys to take on new cases and also, to get them turned around, in just a matter of days. So it is really important if you are considering doing EB5 over the next few months to get going and interview a few attorneys, select the one that you think is the best fit for your situation, and start that process to make sure that you'll be able to meet a deadline, if one does pop up, in the next month or two.
Yeah, absolutely.
All right, so to conclude, we'll just spend 1 or 2 minutes just chatting quickly about some of the currently available rural and urban projects that EB5AN has available. So as we talked about earlier, rural projects have the priority processing, and we're seeing applications for the green card, the I-5 260 petition, get approved in 7 to 9 months or so. And on the rural side, we have 2 projects: our Rocky River project, which is an ongoing master plan community in the U.S. and outside of Charlotte, North Carolina. Thousands of jobs are going to be created from this project. It follows 13 prior Coulter active adult communities that have all been successfully developed or are ongoing as of now. And then our second rural project is a Tamarack Resort. It's an operational master planned ski, golf, and lake community in Idaho. Lots of sales, lots of developer equity, thousands of jobs already created, and has the Form I-956F approval as well. And then on the urban side, and these projects generally on the urban TEA side are going to be shorter investment periods with higher returns for the equity. And so our Boynton Beach project, has a 3 to 4 year target repayment period with a 5% preferred return. And our One Tampa project is a shorter term guaranteed loan repayment project being developed by Coulter, who's also developing Boynton Beach and the Rocky River project. And we've done almost 30 EB5 projects with a perfect track record with Coulter over the last 10 years. So to get any more details on any of these projects, please feel free to reach out. You can use this QR code or just go to our website and schedule a call, a free call with a member of our team. And we're happy to share more details about the EB5 process and about any of our current rural and urban projects. And we're always coming out with new projects as well, in addition to the few that we just went through. And on the immigration side, anything related to source of funds, filing adjustment of status, seeing if your documents for where your money is coming from are going to be sufficient for an EB5 application, all that is going to be Belma. And Belma, maybe before we wrap up, share a few minutes about kind of what that engagement process looks like with you and your team. How do you exchange documents? How long does it take, to get an application together? And yeah, just what does that kind of process look like, from start to filing the petition?
Yeah, absolutely. Thank you. I generally would do an intro call with every prospective client, simply to address the issue of, who are you? Nice to meet you. Are we a good fit to work together? We really take every client as they come, and we work in a particular way. So, and I'm very aware of that, in that, not everyone wants to really work closely with an attorney. Sometimes we have clients who say, like, I never want to talk to an attorney. I just want someone to take care of it. Well, that's not really going to happen in an EB5 space in general, but we do an intro call to get to know each other a little bit. And, if a client decides to proceed with us, we would then exchange the legal services agreement and set up the client with access to our database and secure folder. Everything is done electronically. It sort of moves very quickly. We provide the client with a list of documents that we need from them after we have determined the source of funds strategy. From an investor standpoint, investors have really two things they have to worry about. One is picking a project. Number two is the source and path of the funds. And so we do an individualized exploration session to find out what is the best source of funds for this particular investor that's legally strong and can be easy to document. So once we have that, we provide investors with a customized list of documents. And after that, it's a pretty fast-moving process. A typical investor files anywhere between 2 and 8 weeks, ideally. We really try to move our clients through the process very quickly. We're dealing with financials. They get stale after a while. So we really did, in the conversation, we tell our clients, look, if you think you're going to be applying in September, then, call us in June, right? Like, there's no need to start the source of funds if we know that the documents aren't going to be ready for 6 or 8 months, right? So we're happy to have the intro call. Anyone who reaches out, and we keep those calls to 15, 20 minutes max. And we don't charge them. We don't charge for these intro calls, but that's the best way to get in touch with us and figure out if we are the right fit to work with the investors and get the filings done. Like I said, ideally between 2 and 8 weeks is a great timeline to submit an EB5 petition.
Perfect. Thank you, Belma. And a few other just thoughts on that is, one, just all immigration attorneys are not created equal, right? Some are going to be better than others in terms of responsiveness, timing, availability, language, and then also, the right fit for your particular situation, right? If you're in China, from Hangzhou, China, and you don't speak English, Belma might not be the best fit, right? But, if you're from the US and, you've been working in an investment bank and, you have documents that are in English and you speak English, then, that's completely different.
Our team had, we actually, as most people in EB5, we've handled a large number of investors from China. So we actually do have a team member who is from China and speaks Mandarin fluently. We also have a native Spanish speaker on our team. But I will say that vast majority of our clients are fluent in English because they do come from all over the world. We have a great number of clients that come from Latin America, from Europe as well, Africa also. So really, it's been a really good representation. And in the last couple of years, we've had a lot of clients that are originally from India, and potentially based in Dubai. But, generally speaking, the clients tend to speak English, but if not, we can accommodate a couple of other languages. But you're absolutely right. Like, not everyone, sometimes it's a language fit, sometimes it's a knowledge fit, and sometimes it's just a cultural fit of like how we work with one another and what kind of services suit each investor.
Yep, exactly. Yeah, this is a multi-year relationship. This isn't just hire you once, do something, and then never speak to you again. This is a multi-year journey. There's a lot of updates and things that are going to be happening for families. Circumstances change. So it's really important to pick someone that you really like. And we've seen Belma work closely with a lot of our clients, and she does an amazing job, and she has our strongest recommendations. So definitely
I
do
appreciate
your homework. And yeah, it's always good, to see what's available and what's going to, get your application done correctly the first time. I can't stress that enough. You just want to make sure you get it right going in, because if not, you'll face delays and additional fees, and it'll end up costing more and taking longer than anticipated, which can be avoided by just doing it correctly the first time around.
Absolutely.
With that, thank you again, Belma, for taking some time to share your experience on today's webinar. And yeah, again, anyone interested in source of funds and immigration questions, reach out to Belma directly. And anything about any of the projects we talked about, or new projects that come available in the future, please reach out to us.
Thank you. Thank you for having me, Sam. Take care.